Hello, and welcome to the View from Mayor Brown podcast. This is a fortnightly podcast series for employment lawyers and HR practitioners, which highlights developments in case law and legislative changes of importance to UK employers. It is presented by Nicholas Robertson, the head of Mayor Brown's London employment team. The time spent listening to these podcasts can count towards your training requirements. At the end of the podcast, we will explain how to get in touch if you have any comments or questions.
Hello and welcome to a special guest episode podcast of the Mayor Brown Employment Podcast. I'm absolutely delighted today to be joined by Tom Linden, QC. Tom has been a previous guest on the podcast, so I've done an introduction for him before, but I thought, well, I'd make it a little bit more varied this time, so I went online and looked up Tom Linden and see what the internet had to say about Tom Linden. The very first entry, and I'm not making this up, says, quote, "Tom Linden is one of the most conscientious, creative and efficient composers I know and we've worked with. He's a very nice person to work with as well, which helps enormously when the pressure is on to meet deadlines. In a highly competitive pitch, he won the commission to produce the music for Channel 5 News. He never fails to deliver great ideas to tight deadlines." At which point I suspected I was looking at the wrong Tom Linden. But it's amazing, there's an awful lot in that I think applies to Tom. But this Tom Linden was called to the bar in 1989, won Employment Junior of the Year award 2 years running, became a Silk in 2006, was won Employment Silk of the Year twice as well, and is part of an absolutely top-notch team at Matrix Chambers. Work-wise, does the full range of work-related disputes, and if I just take the employment and discrimination practices, which is but one string to his bow, he's been involved in partnership, LLP disputes, commercial law, contract claims, did a mega bonus case representing Commerzbank. He's been involved in cases connected to LIBOR fixing misconduct, EU human rights, appeared in the European Court of Human Rights and European Court of Justice, has done phenomenal amounts of work at appellate level, and I think the stat that really stands out is since 2000 only one other barrister has done more cases that have been reported in the ILR. So we are absolutely delighted to have him on board for the podcast today, and we asked him to come in and speak about the Pimlico Plumbers case which he was involved in. So Tom, after that rather lengthy introduction, welcome to the podcast and delighted to have you here.
Thanks, Nick.
We thought the best place to start is let's start with the tribunal case, because this is a case that goes up through from Employment Tribunal right the way through to the Supreme Court. But if we start at the beginning of this, so we can sort of sketch out the issues and what was going on here, and then tease out what the wider significance of the case is. Let's start with the facts. What were the claims being advanced in the Employment Tribunal? What was the factual situation that was underlying the claims in the tribunal?
This is one of, as you'll all be aware, one of a series of cases going through the tribunal and appellate court system relating to the so-called gig economy. In this particular case, Mr. Smith was a plumber who's contracted with Pimlico Plumbers. As I imagine the listeners will know, the Pimlico Plumbers rent a Pimlico Plumbers van with Pimlico Plumbers livery on it. They drive in a Pimlico Plumbers uniform, and they work according to Pimlico Plumbers standards in relation to Pimlico Plumbers clients. But on the other hand, as Pimlico Plumbers were arguing, they work on a job-by-job basis. When a job comes in, they quote for it, and they size up the job. They give a price. The price includes the price for materials. They then do the job, and they're not paid unless the customer pays, and that includes full materials. So they run significant financial risk. They're renting a van, they're quoting for work, they're carrying out the job, and they will only get a return on their work if the customer pays, and they're investing in their own materials as well. And so hence the question arose as to their employment status. For the purposes of our discussion, there are two key features to be aware of. One is on the issue of personal service, which is an ingredient of all of the different types of employment status under the legislation. The contract that the Pimlico Plumbers entered into in those days was one which appeared to be addressed to them personally and to make various requirements of them personally, and made no reference at all to any right to substitute. But the facts were that in practice the Pimlico plumbers are entitled and were entitled to get someone else to do a particular job. So they could quote for the job, something else which was more lucrative could come up. They could get someone else to do the job that they quoted for. But the requirement was that they could only, someone else had to be somebody who was an approved Pimlico plumber. And so one of the questions in the case was, assuming that that is a contractual right to substitute, does the fact that you can only send a substitute who's already a Pimlico plumber mean that there is no obligation of personal service, or is it essentially to be regarded as a shift swapping or cover arrangement? So that's one of the key factual features for present purposes. The second key factual feature is that I said that the plumbers work on a job-by-job basis, which is true, but in those days the contractual provisions, certainly Mr. Smith's contractual provisions, incorporated a handbook which referred to an obligation to work a minimum 40-hour week, and hence Mr. Smith was saying, well, I must have some sort of employment relationship with Pimlico plumbers because I'm being contractually required to work a minimum 40-hour week. We were disputing that.
I had a sense, just reading, and obviously I was seeing it at the appeal stages when I was reading it, the contractual documentation was not particularly clear, which I don't think helped Pimlico plumbers at the end of the day. Is that, without being pejorative one way or the other, is that a fair assumption?
That's right. That before we come on to the claims that Mr. Smith was bringing, that's obviously correct. What you had was an original contract which had been entered into in 2005, which incorporated this handbook which had the minimum working week requirement, but it wasn't absolutely clear to which individuals this was supposed to apply. And there was then a further contract in 2009 which very clearly and emphatically stated, or also Pimlico plumbers contended, that there was no obligation on either side either to offer or to accept work. And obviously that was in conflict with the idea of a minimum 40-hour week, which involved a minimum 40-hour service by a given Pimlico plumber. So there was an internal contradiction within the contractual documentation, and that was one of the features of the case that was relevant, and we'll no doubt come on to that in due course in seeing how the case was resolved. Now, if we turn to the claims that were being brought, those claims raised each of the three types of employment status that are relevant to statutory employment protection in this country. So Mr. Smith was claiming unfair dismissal. What had happened was he developed a heart condition. The facts as to precisely what happened are contested, but his case was that the contract was terminated as a result of him raising these issues and saying that he was unable to do as much work as he had previously done. That was disputed by Pimlico plumbers, and in due course, no doubt, an employment tribunal will reach a conclusion about that. But he was saying, well, I was unfairly dismissed. So he needed to show that he was an employee in the strict sense, employed under a contract of service. And the test for that, as everyone will know, is the ready-mix concrete test. And at the moment, all that's relevant for present purposes is to say, well, that test involves, as limb 1, the so-called wage work bargain, which is that an individual undertakes to provide their work personally in exchange for remuneration. You then go on to the question of control, and you then go on to ask, what about the other features of the contract? Are they consistent with a contract of service or a contract for services? So that's employed status in the strict sense, ready-mix concrete employment. He also was alleging unlawful deduction of wages, and therefore bringing a claim under the Employment Rights Act on the basis under which he needed to show that he was a worker, what's called a limb B worker. So a worker as defined by section 230 subsection 3b of the 1996 Act. And again, in order to make good that case, he had to show that there was a wage work bargain, that he'd undertaken to provide services personally to Pimlico plumbers, and that the relationship between the parties created by that contract was not one in which, in effect, Pimlico plumbers was a customer of a business carried on by Mr. Smith. So that's the limb B worker concept. And then he was also bringing a disability discrimination claim. He said that he had a heart condition, that amounted to a disability, that the relationship with Pimlico Plumbers had been terminated as a consequence of the disability, and therefore he was bringing a claim under the Equality Act. Now there he needed to satisfy section 82 subsection 3, where the concept is called employment, but in fact it's a broader definition than employment under domestic law, than ready-mix concrete employment. And the definition there says simply there is employment if there is employment under a contract to provide services personally. So you can see that for all three concepts there had to be an obligation of personal service, which was one of the issues in the case.
Yes.
So that's the first main issue that we're going to be discussing. And also for all three definitions, putting this in broad terms, the nature of the relationship needed to be what's been coined in the case law a dependent work relationship, as opposed to a relationship between independent contractors. Because obviously, if the parties are really, when you look at it, independent contractors, there isn't going to be a contract of employment. Under Lim B, if Pimlico Plumbers was a customer of a business carried on by Mr. Smith, well then they're independent contractors, there isn't worker status. And in the Winkelhoff case, and in Jivraj and Hashwani about commercial arbitrators, it was said that essentially the Equality Act test is the same as the Lim B test. So if they're independent contractors, there isn't any form of employment relationship, and therefore the equality law doesn't apply, or the employment aspects of equality law don't apply. So those are the claims.
So boiling that down into a nutshell, you've got an employment status claim, unfair dismissal.
Yeah.
So I'm an employee, pure and simple.
That's right.
But if I'm not an employee, I'm a worker.
That's right.
Effectively, Lim B worker, and the other legislative tests are very similar to Lim B worker status tests. Okay. So what did the Employment Tribunal decide on those claims?
The tribunals found in a nutshell that Mr. Smith was not an employee of Pimlico Plumbers, but that he was a Lim B worker and or an employee for the purposes of the Equality Act. And for present purposes, the things to note are, well, so why was he not an employee?
Yep.
The Employment Tribunal's answer to that was, well, essentially, in broad terms, because the relationship with Pimlico Plumbers is not sufficiently close. Specifically, the tribunal found that the Pimlico Plumbers was not under any obligation to offer him work.
Right.
Although the tribunal's findings on that were later interpreted in the course of the appeals as meaning it was under no obligation to give him work if there was no work available.
Right.
And secondly, the level of financial risk, which I've referred to, undertaken by Mr. Smith, the tribunal said was inconsistent with employed status. He was having to rent a van. He wouldn't get paid unless the customer paid. He had to pay for his own materials and so on.
Well, I seem to recall, didn't he also get a discount, or there was a tax? He got a tax benefit because he was buying his own materials, and then there was an allowance made.
Exactly.
So you certainly read the facts of that. It didn't feel like an employment case. I mean, clearly, we'll talk about worker status in a second.
That's right.
But I wasn't surprised by the employment decision. It felt, on the facts as found by the tribunal, that was entirely understandable. Okay.
And certainly, if you looked at his accounts, what you saw was a very substantial level of costs being set off against his income, a variety of different things, all entirely consistent with being self-employed, let's put it in those terms, and or conducting his own small business. He was charging. He said that he was paying his wife to work for him. He said he was charging for the use of facilities in his home as an office.
Okay.
He was setting off materials and so on. So I agree with you on the employee status point.
So on the dichotomy of if it were I'm either employee or I'm self-employed, which
That's
is the way broadly the tax regime works, it's entirely understandable. But we've of course going to focus on the middle bit, which is the worker status. Now, so what was the reasoning on the worker status?
On worker status, so you not employed but self-employed, and importantly, of course, the fact that you're self-employed doesn't mean that you're not a worker. In fact, a lot of workers are self-employed.
Yes.
And so the Supreme Court emphasised that in its judgment in the case. So there's, as it were, a fork in the road. You then got two types of self-employed people, said Lady Hale in the Winkelhoff case. Those who are working for themselves as part of their own business, which has customers, and they're obviously not protected by the employment legislation. Those who are self-employed but work for others as part of their business, and who are protected by the employment protection legislation. And the tribunal in the present case didn't put it quite this way, but it said, well, he is a person who works as part of the Pimlico Plumbers business. Now, before they got to that, they needed to deal with the problem of the wage-work bargain that I referred to. So the Employment Tribunal said, well, it may be that the employer is not obliged to offer him work, but he is, under the manual, obliged to offer a minimum of 40 hours service. So he's under an obligation to work. Is he under an obligation to work personally? Answer, yes, said the tribunal. The fact that he can substitute another Pimlico plumber to carry out a job is not sufficient evidence to displace an obligation of personal service. It's really much more of a cover/shift swapping arrangement. So the tribunal concluded, therefore, he has undertaken to work personally for Pimlico Plumbers. And secondly, on the question, but what is the nature of the relationship? Sure, some personal contracts are employment type contracts, some are independent contractor type contracts. The tribunal said, well, he's very much working as part of the Pimlico Plumbers business as opposed to working as part of his own business. And therefore, the nature of the relationship is a dependent work relationship rather than a relationship between independent contractors. So he got through on the LIMBY worker/employee for the purposes of the Equality Act and was able to bring his discrimination claims and his unlawful deduction of wages claims relating to the working time provisions, etc.
Fine. Okay, so we know it goes up to the Supreme Court. So in brief, what happened at the EAT and Court of Appeal? So
in the EAT, there's an appeal by Pimlico Plumbers against the findings against it, i.e. the argument being the tribunal was wrong to find worker status, and a cross appeal by Mr. Smith saying the tribunal's wrong to find I wasn't an employee. And interestingly, his argument was that, well, how can you on the one hand find that the employer has no obligation to offer me work, and on the other find that I have an obligation to do work for the employer?
At which point you probably find yourselves in violent agreement, appellant and
That
respondent.
was the point on which we relied heavily as the case made its way up the appellate structure. It's just that we said that the findings against us were the wrong ones. So the EAT said no, the tribunal was right on both points. Right. In the Court of Appeal, it was only Pimlico Plumbers appealing against the worker status issues. And the Court of Appeal said the Employment Tribunal was entitled to find that he was a LIMBY worker and an Equality Act employee, and so the case proceeded to the Supreme Court.
Okay, so precisely what were the issues that were that went to the Supreme Court? Let's start with that, and then we'll talk about the arguments for and against each issue.
Essentially, the two issues in the Supreme Court were: firstly, does the fact that Mr. Smith is able to provide a substitute as long as it's a Pimlico plumber, does that mean that there isn't sufficient or there isn't an obligation of personal service?
Right.
And then secondly, is it right? Was the tribunal entitled to find that the nature of the relationship was a dependent work relationship as opposed to a relationship between independent contractors? And there the specific attack was on the tribunal's finding that there was a minimum working week of 40 hours. What was being argued was the contractual provisions make clear that there is no obligation on either side to offer or accept work. That is, it was being said, a relevant factor in determining the nature of the relationship. And there's a case called Windle, which we may well come back to, which says precisely that, and it said it in the Court of Appeal. And so it was being said that if the tribunal wrongly thought there was a 40-hour minimum working week, then the whole of the decision on the nature of the relationship was tainted by that error, and the case should go back to be reconsidered.
Okay, all right. So let's take each issue, and let's take the substitute issue. What were the arguments being put up by Pimlico Plumbers? What was the response? And then what was the Supreme Court's decision on that? And then we'll flip and do the minimum 40 hours argument. Yeah. So let's take the substitution. What were the arguments being put up to the Supreme Court for that?
The first point that needed to be established in the context of the Pimlico Plumbers facts was that in fact there was a contractual underlined right of substitution, and the problem for Pimlico Plumbers was that wasn't referred to anywhere in its contractual documentation. On the contrary, the appearance was that it was addressed at the individual and placing obligations on him as an individual and therefore personal to him.
Yes.
Proceeding from there, it was being argued that the practice, therefore, which we were saying reflected the contractual position of being able, if you wished to substitute a Pimlico Plumbers operative, the argument was, well, that means that the individual has a choice as to whether they do the work personally or not. And if that is the case, it was being argued, then there's no obligation underlined of personal service. They can choose whether to do it or not to do it.
Yeah.
So that was the personal service issue.
Just pausing there for a second,
Yeah.
it always struck me when I was reading this. This is in many ways the opposite of the Uber case. Uber case, the document, and I'm generalising grossly, the documents are great for Uber and the facts are not. And here,
Yes.
the facts are much more helpful for Pimlico. The practice is much more helpful for Pimlico Plumbers, and the documentation was the problem.
Yeah,
And
I quite agree.
It was an odd, because usually the documents are on for the
Yeah.
company and the practice is what caused the
Yeah.
problems. But here it's...
I quite agree, and I mean what's been happening in the cases going through the system is that, of course, where the claimant is saying the documents don't reflect the reality of the relationship, the tribunals are showing themselves to be pretty willing to rely on the Auto Cleanse and Belcher
Yes.
case to say, well, when we look at the practice, it's clear that the documents don't reflect what was agreed.
Yes.
But I mean,
Not
fairly
sure it works in reverse. with
exactly, because it's much more difficult if you create the document as the
Yes.
putative employer. The fact that the practice may not reflect the documentation doesn't mean that the documentation isn't the true agreement, because the claimant's answer is to say, well, no, the true agreement is as reflected in the document which you produced. The fact that you choose to waive the obligation or to approach it in a different way doesn't mean that the obligation isn't there in the first place, and they say that's what matters in a case where you're asking what's the nature of the contract.
Into that, and we won't go into it, but into
Yeah.
that, I think you interposed a contractual clause that says we'll have no oral modifications, thank you very much. And
Yes.
we now know that's a valid
Yeah.
clause.
Yes.
So you're trying to work out how that's going to apply to employment relationships, and that's going to be a whole new area for Brexit.
Yes, indeed.
Let's not
Yes.
go there, because otherwise
Okay.
we're here for an hour or two knocking that one around. Okay,
Yeah.
so... those are the arguments being put up to the Supreme Court by Pimlico
On substitution,
What's
yeah.
the response, and where does the Supreme Court come out?
Okay, on that particular issue. So, the basic. There were two answers really. One is, well, actually, there isn't a contractual right in accordance with the practice. What the employer is really doing is waiving the strict position under the contract, and that's the view the Court of Appeal took. And then the second point is, well, even if there is a contractual right to substitute, the fact that it can only be exercised if the substitute is a Pimlico plumber is not sufficient freedom of choice to displace the obligation of personal service.
Right.
Now, the Supreme Court said, well, we don't need to resolve the argument about whether there's a contractual right of substitution which reflects the practice. We're prepared to assume that there is and proceed from there. And the Supreme Court's answer was ultimately, well, it's not a binary question. The way that the case was being presented by me was that the case law is really saying there are cases where you can provide a substitute if you're unwilling to do the work yourself.
Mm-hmm.
And in those cases there is no obligation of personal services because you have a choice.
Mm-hmm.
And it was being submitted, and this is such a case because you have a choice
Yes.
to
And the fact that
send
to
somebody
a
else
limited
along.
pool of
Yeah.
substitutes
Didn't
doesn't
matter.
affect the principle
Didn't matter.
of
Yeah.
it's an unwillingness.
Exactly. And there are various cases in the EAT that said conditionality as to who the substitute is doesn't detract from the overall point that you have an absolute choice as to whether you send a substitute or not. For example, often there's conditionality. They have to be somebody who's qualified to do the work, for example, somebody who's cleared from a security point of view and so on. And it was being said this is no different. That all that's being said is the individual must be an approved Pimlico Plumbers person. Now, so the Supreme Court said, well, we'll assume there is this contractual right of substitution, but we don't ultimately agree that it's a binary question as to is it an unable case or an unwilling case. And what they pointed out is that in the Ready Mix Concrete case, the case on contracts of service, Mr. Justice McKenna, when he dealt with the obligation of personal service, said that a limited that a complete freedom to provide a substitute is inconsistent with an obligation of personal service, but a limited right to delegate is not inconsistent. So they went down the road of saying it's more of a matter of degree.
Yes. The greater the freedom,
yes,
it's a factor, and the greater the freedom, the more it points in one
exactly.
direction, the more restricted.
Exactly.
Yeah, okay.
Exactly. And to sort of bolt that into some sort of legal framework, they revived the Mirror Group and Gunning test. And so what is that? Well, quite important, I think. I mean, Mirror Group and Gunning is a case where you were concerned with a newspaper distributorship. So the father of the claimant had a newspaper distributorship with the Mirror Group, which meant that obviously the idea was that the newspapers got distributed, but he had to do some work himself. His when he died, the daughter wanted to inherit it, and they said, no, ladies can't do that sort of thing. So it's the essential point. And the question was, well, can she bring a claim under the sex discrimination legislation as then was? Is there an obligation of personal service? And it was a case where there was some obligation of personal service, but the main aim of the contract was that the newspapers got distributed. And so the Court of Appeal said, well, in this type of case, what you should ask is personal service the dominant purpose of the contract? Now, in Pimlico Plumbers, in Jivraj and Hashwani, which is the case about commercial arbitrators, the Supreme Court appeared to be saying they didn't find that approach very helpful. In Pimlico Plumbers, the Supreme Court sort of brought it back, not necessarily into fashion, but brought it back and said, well, actually, better to ask about whether personal service is a dominant feature of the case as opposed to the dominant purpose of the contract.
I hear the sound of angels dancing on pinheads.
quite so. But then proceeding from there, what Lord Wilson said, with the agreement of all of the Supreme Court justices, was, if you look at this contract, personal service is the dominant feature, because not least you look at the contract itself, and there's no sign of anything other than it being a contract with an obligation of personal service. The whole point is personal service. The fact that there may be a power to delegate to Pimlico Plumber operatives if occasionally a more lucrative job comes up, doesn't detract from the fact that the dominant feature of the case of the contract is personal service by Mr. Smith.
Yeah.
So a bit of a right to substitute, even if it's entirely a free choice, it doesn't really affect that overall.
Doesn't force you in a particular direction. Or to put it another way, you can't draft your way around it by granting an unequivocal right to substitute. That's probably overstating it.
But I think what the Supreme Court had in mind is that you're still ultimately concerned with the nature of the contract, and you're really asking, is this a case where the basic idea is that they will personally work for the other party to the contract, and if on the other hand the basic idea is that the work will get done, the other party to the contract doesn't particularly care who does it, then, as in the distributorship type of case, then the fact that there's some obligation of personal service doesn't really detract from the overall nature of the contract.
I understand.
I think they also said quite useful clarificatory things about the nature of the right to substitute, because one of the points that was being made and was indeed ultimately accepted by the Employment Tribunal was that Mr. Smith could also bring along people to help him to do the work. So if there was a specialist task, I mean, he had particular expertise, but if he turned up and it actually needed somebody with heating engineer expertise, he could get somebody in to do the work alongside him. And the Court of Appeal said, and the Supreme Court endorsed the point, that wasn't a right of substitution. That was a right to bring someone else to assist you. What you're always concerned with is the question: is the dominant feature of the contract that this particular individual has agreed that he or she personally will do the work under the contract? And if the answer to that is yes, then the ability to substitute in particular circumstances won't detract from the overall conclusion. So it's a more nuanced approach to the personal service point.
Okay, so let's talk about the 40 hours a week, minimum 40 hours a week point, and what were the arguments there? And what were the counter arguments?
Yeah. Well, this threatened to be a more interesting point, but in the end, ultimately wasn't. The point stems from a case called Windle in the Court of Appeal, where essentially you were concerned with people who worked as interpreters, engaged by the Ministry of Justice in different sorts of cases, county court, crown court, etc. But they quite genuinely worked on an ad hoc basis and case by case, you might say, and that included working for other clients, not necessarily in the courts, not necessarily for the Ministry of Justice, etc. But they did do a lot of work for the Ministry of Justice, and so the question was, what's their employment status? The answer given was by the employment tribunals, well, they're not workers because they work on an ad hoc, intermittent basis. And the EAT said, well, that's irrelevant because you can be a worker during the periods of work, which is very well established. And it's the basis for all of the gig economy cases where the claimants succeed, that when somebody says, yes, I'll work, then clearly they are entering into a wage work bargain. And then the only remaining question is, well, what's the nature of the relationship when they're doing their work?
Yes.
Now, Lord Justice Underhill said, correctly in my view, it must be relevant that they're working on an ad hoc basis or an intermittent basis. That must be relevant to the nature of the relationship. It clearly, if they are not working on an intermittent basis, they're contracted to work a minimum working week, for example. That points to an employment relationship. If they can work as and when and don't have to work at all, then that points away from an employment relationship. Not decisive, but it's relevant.
So logical.
Yeah.
Of course.
So that's what Windle says. The argument for Pimlico Plumbers was, well, in this case, the tribunal has said there's a minimum 40-hour working week. And we entirely accept that if that were the case, that would point strongly to some sort of employment relationship, a worker relationship. But that isn't the right analysis of the contractual documents because of this clause which says there's no mutual obligation to offer and accept work, which we said had superseded the provision in the manual. And that was the essential argument. So they got it wrong, the contractual analysis wrong. As a consequence of that, they analysed the nature of the relationship incorrectly, and as a consequence of that, what you should do is send it back for them to do it correctly on a basis of a proper understanding of the contractual relationship, which is essentially a relationship of casual worker or casual individual to business. Now, the other side were arguing, interestingly, that Windle was in fact wrong in this sense, that they accepted that the fact that an individual works intermittently is relevant to the nature of the relationship. But they were saying that rather than pointing away from employed status, it pointed towards it. So they were saying, and they produced a number of learned academic treatises to support this, that, of course, if you're working intermittently, there's no commitment to offer you work, then that points to a more dependent, more subordinate relationship, and so it ought to tell in favour of worker status as opposed to independent contractor status. Now, Nicholas is rightly looking quizzical about that, because
sounds
it is
like heads I win, tails you lose.
Yes, it's with respect to the learned academics, an odd argument, because it may or may not is the answer. If I can pick and choose who I work for, that may well be strongly indicative of independent contractor status. And so my personal view is that Windle is obviously right. All that it's saying is that this is a relevant consideration.
Yes.
Now, what the Supreme Court said is, well, actually, we don't need to engage with any of that because we don't agree that the tribunal was wrong in holding that there was a minimum 40-hour working week. And so the question of intermittent versus minimum working week doesn't really arise. There was a minimum working week. It was a minimum of 40, and so the tribunal is perfectly entitled to reach the conclusion that it came to, particularly bearing in mind the other features of the case, and in particular the level of integration of Mr. Smith into the Pimlico Plumbers business. I mean, the way that they did that was possibly involved creative thinking, shall we say, on the part of the Court of Appeal, and then endorsed by the Supreme Court. in the sense that what they had to do is the tribunal clearly said the employer is under no obligation to offer Smith any work. They had to read that, they had to dilute that by saying, well, actually what they meant was that he was under no obligation to offer any work if no work was available. And so they said, of course, the converse of that is that Pimlico Plumbers was obliged to offer work if there was work available.
When I said would, I meant wouldn't.
It was, yeah. So that was what they said on the putative employer side of the mutuality obligation, and then on the Smith side, the claimant side, they said, well, when they say minimum 40-hour working week, they're not saying they're not saying that every week he will work 40 hours. They're saying he must hold himself available to work 40 hours. We had said, well, that would be a bit surprising because he doesn't get paid unless he's provided with work. But nevertheless, the Court of Appeal's analysis was accepted, and so they said, well, there is effectively a wage-work bargain here, that the employer will offer him work when it's available. He will hold himself available to do a minimum of 40 hours. Of course, when he does the work, he'll be paid. And so, given that there's a 40-hour working week, there is no problem with the tribunal's analysis on the facts.
Fine. Okay. Was there an attempt to argue, I think I picked this up, there was an attempt to argue that the test for disability discrimination purposes, the in-employment test, was slightly wider or more pro-individual again than the worker status test, and the Supreme Court declined. It was trailed and argued energetically, or whatever the phrase was.
My opponent was arguing the point about Windle energetically, and there were murmurings of discontent about the case law on the point about European law. The point is ultimately this, that there is case law in the Court of Appeal. Halawi is one of the cases which was referred to the Supreme Court, or referred to in the Supreme Court. Another case is X against West Sussex CAB, which is a case about volunteers working in the Citizens Advice Bureau. And another case is Gillam and the Ministry of Justice, where what's being developed is an argument that if you're concerned with employment rights that are underpinned by European law, then the European case law says that you're not particularly interested in the position under the national law of contract. What you're interested in is the substance. Is there ultimately an agreement to provide services personally in exchange for remuneration, whereby the individual works under the directional control of the putative employer, and you're just interested in the substance of it.
Yep.
Now, that point that is there a contract under national law appears to have been accepted by the Court of Appeal in Halawi and the X and West Sussex case, and then in Gillam in the Court of Appeal has said that you could, at least in principle, read down the domestic definitions. So the domestic definitions appear clearly to require a contract. But in principle, they said if they'd needed to in Gillam, they would have been willing to consider reading out of the definition the requirement of a contract and simply looking at the substance of the position, European approach, where you're concerned with European rights. So discrimination rights, working time rights, those types of things. That argument is available.
It's developing, but
it's developing,
and the Supreme Court didn't want to get embroiled. Or didn't get embroiled.
It hadn't been run at any level below the Supreme Court, and so it wasn't run with any conviction in the Supreme Court, and the Supreme Court didn't want to deal with it. The reason it matters is because you could, at the moment, if the position is governed by domestic law of contract, then of course you can draft contracts to defeat employment rights. At least in principle, as long as they're genuine clauses.
Yes.
So
Belcher.
Exactly. Auto-claims and belts. So for example, on personal service, if you had a clear provision that said, we absolutely accept that you're under no personal obligation to do the work and you're completely free to provide a substitute
in Deliveroo
of your choice. Exactly.
That was accepted. Exactly. That was the bargain.
The contract will then prevent employed status. The argument to that is, well, under European law is, well, actually, it doesn't really matter what the contract says as long as in substance they agree to provide the work personally. Now, there are difficulties with all of that because we have our own domestic concept, which is the auto-cleanse concept. if the conclusion is that the contractual term is genuine, even if it's not regularly exercised or even exercised at all, then it's difficult to see how you could nevertheless say that in substance they've agreed that they have an obligation of personal service. Do you see what I mean?
Yeah, I do.
Yeah.
And I was just trying to work out where that would lead, and I'm pretty with some
Yeah.
leaps and bounds here. But there were those cases involving agency workers where their attempts to claim employment or worker status with
Yes.
the customer were defeated
Yes.
on the grounds there was no contract between customer and the
That's
individual.
right.
It was perfectly logical that there was a relationship.
That's right, all
With-
explained by
yeah.
the contracts between the other parties.
And
yeah.
you've got that case going through
Til-
with the activist union against the University of London, I think it is, where
Yeah.
the cleaners are claiming the right to be involved with collective bargaining. It's been outsourced,
Yeah.
and they're saying that the original employer, for whom they are effectively indirectly providing
Yeah.
services, they've got a right to have, I think, recognition or collective
Yeah.
bargaining rights or something, and it's a sort
Yeah.
of dual employment case, which would be groundbreaking.
Yeah.
Sounds as that might well be caught up in all that.
Yes, it's. I'm doing the Addison Lee case at the moment for the Addison Lee drivers, where the tribunal found there was an overarching contract, despite contractual provisions saying there was no mutual obligation to offer and accept work.
Right.
And we've argued that must have been about a month ago now in the EAT. So the judgment will come out on that, which will shed some light, I think, on how you go about deciding whether there is in substance a contract between the parties, despite what the documents say.
Fascinating. So, in terms of points, takeaway points from Pimlico Plumbers, from the outside, having read the Supreme Court judgment, of course, which is with the wisdom of hindsight, I was slightly surprised that it went to the Supreme Court,
Right.
and that there would seem to be issues that would attract the Supreme Court's attention. If we answer it after the event rather than what led to the appeal being heard, are there any sort of takeaway points that you would say, whether it's lawyers acting for individuals or unions or for gig economy or wider employers, are there any sort of takeaway points that you say, I think the thing you should really bear in mind about this case is this?
I think quite limited, actually.
Right.
As to why the Supreme Court gave permission, ultimately, that's pure guesswork. But the panel that looked at the question of permission included commercial Supreme Court justices,
right.
And so they may well have looked at the case and thought that the contractual analysis was suspect,
right?
But obviously we don't know. There was also the possibility, obviously, that other points would become quite important. This point about Windle, which ultimately they didn't think they needed to address. In terms of what emerges from it of any significance, the answer is, I think, only in relation to the personal service issue.
Yes.
As we discussed, I wouldn't look at it as the key thing is don't put in any requirement for them to provide a substitute who is already part of the organisation. I don't think that's the real conclusion. I think the real conclusion is that on the question of personal service, don't look at it as a binary issue. If it's a case where they can choose to send a substitute, well, then there's no obligation of personal service. If it's a case where they can only send a substitute if they're unable or unwilling, then there is an obligation of personal service, but with a default option, with a sort of with exceptions. Don't look at it that way. Look at it in terms of an overall consideration of the nature of the contract, and look at it in terms of whether, when you look at the contract as a whole, bearing in mind any right of substitution, you can say that such obligation of personal service as there is a dominant feature of the dominant feature of the contract. 'Cause that goes to its nature. Is it a contract of personal service?
Sure.
I think that's what's emerging from Pimlico Plumbers, and obviously that ultimately is the law travelling in a direction that's favourable to claimants, because it means that you can draft in substitution clauses that may provide us quite significant rights of substitution, but the court can nevertheless say, but overall, looking at this, the reality is that it's a contract of personal service.
Yes.
Sure, there may be occasions on which they choose not to do the work themselves, but the basic idea is that the individual will do the work.
Fascinating. While I think of it, Uber, where are we at with Uber?
That's coming up at the end of October in the Court of Appeal.
Okay, interesting.
Yeah.
Because I think that again may well shed further light on this area, I suspect.
It may do, yes.
Yes.
I can't comment because I'm involved.
No, and I'm not going to ask you to comment. May shed further light. That's all I was going to say. Let's be cautious. Let's not push it any further than that. Thomas, you know, I always like to end on a non-work related question. And I remember we had your book. We had your book club recommendation last time round. So
right.
I wondered if you had a recommendation for a book for a summer read. On the basis we're all heading off on our summer vacations soon. What would you recommend and why? Alternatively, you could compose some music for the Channel 5 News, and I'm happy with that.
No, I won't do that. I would suggest two books, though it very much depends on what mood you're in. You'd have to be in a particular mood for both books, I have to say, but neither is going to cheer you up.
You're selling it hard now.
So I recently read, I should have read it a long time ago, Never Let Me Go by Ishiguro. It's left a real mark on me. Just
haunts you a bit.
Achingly sad book, and I just don't know how he managed to achieve that. That you can even now talking about the book, I can feel the sadness.
Gosh.
So, but whether you want to, I mean, I just think you want to read it because you may like that type of book, but also wondering at the skill of somebody who managed to do it, to leave that impression. The other one is Blood Meridian, Cormac McCarthy.
Another cheery one.
Oh, it's such a laugh, but it's grim. That's a book of our times, because it reminds us that America is a country built on brutality and violence, and when you see the shenanigans involving Donald Trump at the moment and various of his followers, it all fits together. Yeah. So reading Blood Meridian, I think is I mean, it's a really it also has the most amazing prose, stunning prose, but also a level of violence and brutality that tells you a lot about where the current version of America started, and of course the old version of America was brought to a bloody end.
Yes. Okay. Well, I'm hoping that next time when we have you back, we're going to have something, P.G. Wodehouse, or something a little lighter for the listeners.
Sorry.
No, that's fine. I always like asking that question because you never know what the answer is going to be or why.
Yeah.
I asked one of my partners who does global immigration partner on, and I asked her, and she chose a bit of music. I said, why? And she said, because my father used to sing me to sleep with that piece of music, and you just get a fantastic little insight into something. I like that. Tom, that has been absolutely fascinating. An hour has simply flown by, so thank you very much indeed.
It's a pleasure.
And I hope you come back the next time you're in the Supreme Court on something else. But for now, thank you very much.
Thank you.
So that was our latest podcast. We hope you found it useful. If you have any questions or comments, please email Nick on nrobertson@mayorbrown.com. Our podcasts are an overview of cases. How the law applies in any particular case will obviously depend on the individual circumstances. So please take legal advice if any of the matters discussed are relevant to issues that you are dealing with. And thank you for listening.